Hello again. This is Part 5B. I'm Kenneth L. Roth Jr. As I had stated in Part 5A, after Charles Donahue, the judge, was informed that both defendants committed perjury, he did nothing about it. I also requested the courts, after I had requested from the defendant's attorneys, I don't have their names at the present time, but that will be available. Under the motion for discovery, I filed a request for documents that is relevant to the case, that was covered in the depositions of Mark Kantz and Mark Clare, and yet the defendant's attorneys objected, and that they never did give me the documents that I requested. I requested Charles Donahue, the judge, the court, to have the defendants release those documents to me, in which he denied that. He denied every request that I had that was relevant to the case. Some of my motions, he states, was against Ohio civil procedures and rules. Now he was making me stay within those boundaries. However, he allowed the defendant's attorneys, he allowed them to not follow the rules. I had filed a motion. They had 14 days to respond, plus 5 days delivery, mail delivery. The defendant's attorneys did not do this. In fact, when they did file their answer to my motion, they were 20 days past the allowed 19. I objected to this. Charles Donahue allowed it. He did everything possible within his power, or his abuse of power, and his professional misconduct, to allow the defendant's attorneys plus the defendants to not follow the rules. And since I was acting as my own attorney, he was more than abundant. He was made it more than abundantly clear that I was going to have to follow the rules. Just because I don't have a law degree, I have to follow the rules, and just because they have a law degree, they're allowed to break the rules and not follow the rules. Charles Donahue broke the rules. Charles Donahue needs to lose his law license. He needs to lose his seat on the bench of the Lucas County Common Pleas Court. He needs to be charged for professional misconduct, fraud, and possible bribe acceptance by the defendants. I'm not saying he accepted a bribe. I'm saying there's a possibility of it. He could have done what he did just for the protection of Mark Clare and the two attorneys that was representing them. Now, mind you, this brings another point. When I first filed the lawsuit, Mark Clare, acting as the estate attorney, hired a firm, and there was one attorney. Now, she was filed an answer to my complaint, to my lawsuit. I then filed an answer. The next thing I know, Mark Clare hires yet another firm. Now he has two law firms representing them, Mr. Clare, Mark Kantz, and Seville Kantz Trust, to fight little old me. They definitely knew. He knew he was guilty. I have proof that he was informed about this, the rats and everything, and he did nothing. I have proof that Mark Kantz was notified. He did nothing. I have proof that I notified Seville Kantz, and she did nothing. I also have proof that I supplied the judge with the knowledge that both defendants committed perjury, and he did nothing. I have proof where I filed for the motion for discovery, and he denied that motion. I don't understand how a judge would risk and jeopardize his seat on the common pleas court just to protect a lying attorney, and Mark Kontz, who has a felony record for not paying child support. I have a copy of this as well. This is the end of Part 5B.